Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case Seila Law LLC versus CFPB. Let's go ahead and jump into the facts of the case. The facts are pretty lengthy here because that's where most of the discussion is at. To understand what this case is about, we need to know what the CFPB is. The CFPB, the Consumer Financial Protection Bureau, was developed and created by Congress in the wake of the 2008 financial crisis. It was pushed by then law professor Elizabeth Warren, now senator. Basically, the idea was that we needed to ensure that consumer investment products were safe. We couldn't allow consumers to get into products that are unsafe, right? We need to make sure that those types of products are safe. And so we're going to create an independent agency that's tasked with overseeing these consumer investment products. This agency is different from other independent agencies that we might know, like the FTC or the SEC, who are headed by commissions. Now, the CFPB is headed by a single director. There is one director that calls all the shots for the CFPB. And it's also important to know that the CFPB has a lot of executive functions. It's a powerful agency. The CFPB can subpoena folks. It can issue investigative demands. It can bring you before the CFPB for an adjudication. It can make agency rules. It can even sue you in federal court. So you could see a CFPB versus Alex Dolphin. Hopefully never, but you could maybe see something like that, right, with the CFPB. Now, the director of the CFPB is appointed by the president and confirmed by the Senate. It is a principal officer. But that director has a tenure protection. Congress sought to protect this director from, policy disagreements, essentially. They were trying to make this director independent. And so what they did is they put a protection standard on the director. And that protection standard was inefficiency, neglect of duty, or malfeasance in office. So that means that once this person is appointed by the president, and this person has a 5-year term, the director of the CFPB has a 5-year term, so it's very possible, if not likely, that these folks will carry over from one president to the next, right? Presidential term is 4, this term is 5. Now, what that means practically is that the president cannot remove or fire the head of the CFPB if they just don't agree with one another, right? There's other agencies where perhaps, the folks might not agree and they're protected. The SEC, we kind of know that. The FTC, we kind of know that. But, the Secretary of Transportation, the head of the Secretary of the Treasury, those folks are removable at will. If the president doesn't agree with the policies that they're making, he can just say, hey, sorry, go away. Or she can say, hey, sorry, you're fired. Adios. And it's no problem. But Congress didn't want the president to be able to do that with the director of the CFPB, and so they put this protection standard. All right. So what is Seila Law? Well, Seila Law was a law firm in California that was basically helping clients with some debt collection purposes, right? And so they were issued an investigative demand. The CFPB said, hey, we need some information from you, Seila Law. Looks like you're violating some Fair Debt Collection Practices Acts. All right, so we got to bring you in and basically tell us what you're doing. You're in trouble. Seila Law says, no, essentially, go fly a kite. You're not constitutional. You can't tell us what to do. And so this makes its way all the way to the Supreme Court. And Seila Law's argument is that because the CFPB wields significant executive authority, this director of the CFPB needs to be removable at will by the president. So there can't be that tenure protection for the head of the CFPB. Now, the Supreme Court, Chief Justice Roberts writes the opinion, finds that very persuasive. And they rule that the CFPB's tenure protections violate the separation of powers. And so they essentially, they redline that from the statute and they sever that. They get rid of it. The CFPB still remains. It's still there. But the holding is that Congress could not effectively insulate the director of the CFPB from presidential influence by saying that he was only removable for good cause, essentially. And it's a more elaborate standard than that, but saying that the president can't fire him at will. That was the problem that the court said. And the court gave a variety of reasons. I think the most important one was that the court said it's the president's job to execute the laws. The president is very accountable to the people. He's elected by the whole nation every 4 years. And it's the president's job to make sure that the laws are faithfully executed. That's his constitutional duty. And if he doesn't have control over agencies like the CFPB, which wield significant executive power, and by that I mean they can sue you in court, they can bring you before them, and you can have an agency adjudication before the CFPB, or they can make agency rules. So there's significant executive power. They are executing the law. That's the essence of what the CFPB and the director is doing. And when an agency is doing something like that, the court says, and is wielding significant executive authority, well, that has to be subject to an at-will removal by the president. So that's the holding. And Justice Roberts goes through the Federalist Papers. He goes through some writings in George Washington's journal. It is a very structural, foundational opinion. But it's also important to note that the opinion kind of limits this to the CFPB is, it's limited largely to single-headed independent agencies. And there's not a whole lot of those. The CFPB was one of them. The FHFA is another one, which was dealt with by the court in Collins v. Yellen. There's another one, the Social Security Administration, but there's not a whole lot. And so the court kind of tries to make it clear that this is not going to impact the SEC. It's not going to impact the FTC. We're not overruling Humphrey's executor that says that you can put, tenure protections on independent boards, independent commissions. This is kind of a narrow holding, and that's the way they write it. Now, Justice Kagan, she does not like this opinion, and so the liberal bloc of the court writes a dissent where they're saying, this is just, Congress set it up that way, right? Congress is accountable to the people. And it's kind of this argument back and forth where the liberal bloc is saying, no, Congress is the most accountable to the people, and the conservative bloc is saying, no, the president is more accountable to the people. Essentially, the foundation of that argument made by the liberal bloc is that, hey, Congress can delegate this authority away, they can get rid of it, and if they feel like it's important to insulate some people from political pressures, they can do so. The Constitution is silent on removal. It says nothing, okay? And so Congress is acting in this silent space, and normally where they're acting in a silent space in the Constitution, what they're going to do is going to be constitutional. So they're saying, you're kind of like reading the Constitution to have this removal provision that's not really in there, and now you're treating it too strictly. And then they basically are sounding the alarm and saying, hey, this could potentially be a big problem for other agencies like the Social Security Administration and many other people in the civil service, and we don't want this to go too far. I think the most interesting argument that is it is addressed in this opinion is that this is a single-headed agency, and the president could perhaps exercise more control over a single-headed agency than the president could a board of people, right? Because if you're just trying to influence one person, that might be easier than trying to influence 6 or 7 people, 9 people perhaps. So you can see how there might be a little bit of tension there. And basically the dissent is saying, all right, well, here we go. Humphrey's executor is not going to be around too much longer. And the concurrence with Justice Thomas and Justice Gorsuch is saying, yeah, you're right. Humphrey's executor is not going to be around that much longer. They're saying we want to get rid of it as soon as possible. And you have to think to yourself, what would our government look like if we didn't have any independent agencies that carried over, through presidential terms? President Biden gets in there, appoints all new SEC commissioners, all new FTC commissioners, and then President DeSantis, I don't know who it's going to be, gets in there and takes everyone else out. And you could see how this world might look where now the SEC is totally partisan, the FTC is totally partisan. What does that mean? Is that bad for the citizens of our country? Or is it good? Because now those folks are more accountable at the ballot box to the president, And so these are types of questions that the court is dealing with. It's a hot topic. And as you see in Collins v. Yellen, the case that the court took up at the end of 2020 and issued its opinion in 2021, there's a lot of movement in this space. And so it'll be interesting to see where this buttons up and how things land in the next few years. Thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. And I hope you have a nice rest of your day. Bye-bye.